I'm Steve Broach. I'm a barrister at Doughty Street Chambers and I specialise in cases involving disabled children and their families, and I also advise a range of charities and public bodies on the law in relation to disabled children. Before I became a barrister, I was a campaigner and I worked for the Every Disabled Child Matters campaign and also at the National Autistic Society and Treehouse, that's now ambitious about autism. I'm going to be giving some general information today about the law and how it can be used by parent carer forums to progress their work. Nothing I say today should be used as advice on an individual case, because the law in this area is complicated and families who want individual advice need to seek it from a specialist lawyer. For many people, the law feels very remote from their lives, and it's not at all clear how you can use the law to access any support or services that you might need. The legal framework isn't just a theoretical framework, it is very real, and you can access legal advice and support still to help you enforce your rights, and there is legal aid available still in this area, so that the issues around health, education and social care remain within scope for legal aid, and it's still going to be for families the child's means that are assessed in financial terms, so that most families will still be eligible for legal aid advice. Very often, of course, issues can be resolved without getting lawyers involved, and there are a host of very important advocacy organisations who will support families to access their rights. But better still, if parent carer forums can understand the law and can use the legal obligations in their ongoing discussions with public bodies, then we'll get to a situation where the law is being complied with as a matter of course, and rights are being respected routinely, without having to rely on families taking legal action, which is always going to be costly and expensive and will have uncertain outcomes. So legal action should be the last resort. What we want to see is a culture whereby human rights and the legal duties are respected in everything that's done in relation to disabled children and families. And I think parent carer forums have an absolutely central role to play in making that happen. Parent forums need to understand how the law impacts on their own work, and one of the key areas in which parent forums have legal obligations is towards the data that they hold on parents and children and other people who are involved in their work. And very often small organisations, including forums, won't necessarily understand that they do have these duties under the Data Protection Act, and that there are actually some very serious consequences if data isn't kept securely, if people's consent isn't obtained before it's used, and if they're not registered with the Information Commissioner when they need to be, and some forums will need to be. These issues are very complicated, but there's a very helpful website that the Information Commissioner's Office runs, ico.gov.uk, and any parent forum that is concerned about their obligations in relation to data protection should definitely look at that website and contact the Information Commissioner's Office to find out more about what their obligations are and how they can respect them. At the same time as considering what parent forums are required to do, it's also very important that parent forums know what legal tools are at their disposal in their own work. And one example of that is the Freedom of Information Act and the way in which freedom of information requests can be used to get information from public bodies about pretty much anything now, apart from information in relation to individual cases. But parent forums can use the freedom of information provisions to get information that may not otherwise be forthcoming about important developments in the way services are going to be configured or commissioned in their area. Hopefully, much of that information will be there already and the law won't be necessary, because if there's a good relationship between the local authority, health bodies and the parent forum, the information flow should just happen as a matter of course. But if there are difficulties in getting information, the Information Commissioner's Office website has very useful information about how the Freedom of Information Act can be used, as well as the Data Protection Act. So that will be the first port of call for any parent forum leader or representative who wants to understand more about freedom of information. Parent forums are going to be much more effective, in my view, if they understand what the law requires in terms of services and support to be provided to disabled children and their families. And the three key areas for disabled children generally are going to be education, health and social care. I'll talk about education first, because that is at the heart of a good life, of a good outcome for everyone, including disabled children. And there are very important rights that the law currently prescribes in terms of education for children with special educational needs and disabled children. Most children will have both special educational needs and be disabled, but the definitions aren't completely aligned. Special educational needs provision for children with significant needs is of course set out at the moment in statements. And the key legal duty under the Education Act 1996 is on local authorities, not schools, to arrange the provision that's set out in the statement in terms of the education provision. And that duty is absolute. So it can't be got out of because of, for example, a lack of money or a lack of staff. And the courts will require local authorities to do whatever it says in Part 3 of a child's statement, and schools are required to educate the child if they're named in Part 4. So these are very powerful legal protections and need to be well understood so that parent forums can communicate the rights that parents have to families, parents and children have to families. The other big issue in terms of education law, in my view, is to understand that it's not acceptable for disabled children to be simply without education. And far too many are outside the education system and getting no education support, or perhaps a very minimal amount of support, the typical provision being 2 hours a day of home tuition. That isn't good enough, and it's also not what the law requires. Section 19 of the Education Act 1996 says that local authorities have a duty to provide suitable education to children who might be without it for any period. And that means for disabled children, apart from those who perhaps have complex health needs, full-time education. So the only reason why less than full-time should be provided is if the child's own needs are such that that isn't suitable for them. So these two duties taken together, the duty to implement the statement and the duty to provide support for children who are out of school, should provide a comprehensive safety net for disabled children to make sure that they're always getting suitable education. They don't provide that in practice, and that's why we need to make sure that everyone understands the legal framework better. Parent forums will of course be aware that the government is proposing very significant changes to the law in relation to the Education Act, that Part 4, which sets out the provisions at the moment for special education, will be replaced by the new Children and Families Act, and we have a draft bill now which sets out what the government is intending to change. Now, the changes aren't perhaps as radical as some people had thought they might be. There will be a new health education and care plan, but in practice this won't look very different from a statement if the draft bill provisions become the final provisions, because it will still be the case that only the educational provisions set out in the plan will be directly enforceable. There will only be a duty to provide what is in the educational section of the joint plan. And so parents of children who have health and care needs will have to look elsewhere in the legal framework to find what rights they have to access that support. There will be an important new joint commissioning duty, which should see better joint commissioning decisions made in individual cases across education, health and social care. But that's still not the same in legal terms as the child having a right to a particular level of health or social care support. The other major change that's being suggested that I see as being very good news is that academy schools will be put onto the same footing as other mainstream schools and won't be any different in terms of their duties towards children with special educational needs once the new bill becomes law. So disabled children and their families will still need to find rights to social care and health support elsewhere in the legal framework. It doesn't seem to me, at the moment at least, that the new joint plans are going to deliver rights to health and social care support. We do, of course, have something of those rights already in the law, and there's no suggestion that any of the existing rights are going to be taken away. And in terms of social care services, the Children Act 1989 is the starting point. Section 17 of that Act says that all disabled children are children in need, and that makes them eligible for support social care services like, for example, short breaks or play schemes. But it doesn't give them a right to those services. The right to the service comes from the Chronically Sick and Disabled Persons Act 1970, so a law that's now over 40 years old. And Section 2 of that Act says that local authorities have a duty to provide services to disabled children and disabled adults to the extent they consider is necessary to do so. And the way they find out whether it's necessary to provide the service is by doing an assessment under the Children Act, which is why those assessments are still so important, alongside any assessment that may be done for a statement or a new joint plan. The problem with the 1970 Act is that the House of Lords has said that local authorities are allowed to take their resources into account when they decide whether it's necessary to provide a disabled child or a disabled adult with support. So there's no absolute right to services, because local authorities are allowed to have eligibility criteria which decide whether or not the child or the adult is eligible for support. What they're not allowed to do, though, importantly, is limit the amount of support that an eligible child gets. So once it's accepted that the child needs a service of some kind, the duty is to provide whatever level of service is sufficient to meet the child's needs. And we now, of course, know that in very many cases, the service won't be an actual service, it will be an amount of money. It will be a cash payment in the form of a direct payment. And the duty there is for the local authority to provide an amount of money through a direct payment which is sufficient to meet the reasonable cost of securing the necessary services. So throughout the social care system, there's really three key duties on local authorities. They have to assess what level of need the person has. They have to decide whether or not that level of need is sufficient to warrant a service. And then they have to provide the service that is sufficient to meet those assessed needs. Now, if you can break the law down into three words, assess, decide, provide, you're doing fairly well. But the reality is, of course, a bit more complicated than that. Families will continue to need legal advice where they have particular disputes, but it's going to be very helpful if parent forums are able to explain the basics of the legal structures and systems to families, because then they can advocate for themselves and communicate with local authorities, remind them what the law requires, and hopefully avoid more costly and expensive disputes coming down the line. Very many disabled children will need health services different and additional to those that the general population requires. The NHS in this country remains free at the point of need, but there's no absolute duty to provide every health service that a person needs. And so the way in which disabled children with complex health needs will be assessed for additional health services is through a continuing healthcare assessment. And there's a relatively new national framework for children's continuing healthcare with a decision support tool that sets out the factors that PCTs and the new clinical commissioning groups are going to have to look at to decide whether or not the child's health needs are severe enough to require them to have a health service. The law on the interface between social care and health services is very complicated, and it's different for children and for adults. But one thing is clear, which is that local authorities are not allowed to become a substitute NHS. So if a child needs nursing care or other very complex health services, then it's going to be the legal responsibility of the NHS to provide that, not the local authority. The big difference between children and adults is that for adults, there's an either-or split when it comes to continuing healthcare. So if your healthcare needs are such that you're eligible for NHS care, it's unlawful for the local authority to provide that care to you. Whereas for children, it's expected that in almost every case there will be a joint package of care, even for children with the most complex health needs, because apart from anything else, all those children require education, and that's a local authority service. So the boundaries are much less clearly defined for children than they are for adults. That can be good because it can bring more budgets together to provide the support, but it can also lead to potential for drift and confusion as to who is taking responsibility for the child. So that's why the joint commissioning duty that's being suggested could be very important, and also why, if the education, health and care plans do assist in joining up services across these three areas, that would be very welcome. But I am concerned that without a new legal duty on health or social care, that the plans will not be particularly different to the current statements that we already have. The legal framework around transition to adulthood is complex, and there are different legal requirements in terms of transition across education, health and social care. We've already talked about how the health duties change very considerably when a young person turns 18, because adult continuing healthcare is an either-or split. In terms of social care, the duty under Section 2 of the Chronically Sick and Disabled Persons Act 1970 is actually the same for children as it is for adults, but there's different guidance for adults, and that guidance, which is now called prioritising need in the context of putting people first, tells local authorities that they have to have eligibility criteria set at one of the four bands of need, which are critical, substantial, moderate and low. And it's only those people whose needs reach the band that is the eligibility floor that get a service. So that may mean that someone who's eligible as a child for support isn't as an adult, or potentially vice versa, and that can cause some real problems. In terms of education, Statements, of course, are only at the moment applicable for children who are at school. They don't go on to further education. And that's one of the key things that will change if the new draft bill goes through, because the joint plan will run from 0 to 25, and that has obvious sense to it. But what we do have at the moment is a duty to carry out a learning difficulty assessment under Section 139A of the Learning and Skills Act 2000. And that, in a sense, operates as a quasi-statement for further education, because there's a duty to carry out an assessment of the child's educational and related care needs. And as that child becomes a young person and moves on to further education, a duty to put the right provision in place to make the further education provision work for them. So it's probably not very helpful that at the moment we have a disjointed system with two separate sets of duties, one around statements and the other around learning difficulty assessments. But it's very important to understand that we do already have duties on local authorities that extend up to 25 for young people with special educational needs who want to carry on in further education. In 2005, the government introduced a very important new law in relation to mental capacity, and the presumption now under this law is that everyone has the capacity to make decisions that affect them, and that presumption has to be disproved with evidence about the person's difficulties and needs. And very importantly, in almost every respect, the Mental Capacity Act applies to young people when they turn 16. So this is not a duty or an area of law that only kicks in on the person's 18th birthday, but in fact from their 16th birthday onwards, the presumption in law is that they have the capacity to make their own decisions. There are some critical principles in the Mental Capacity Act, one of which, and one that's very well known, is that any decision that's made on behalf of a person who lacks capacity has to be taken in their best interests. And that means that all of the relevant factors about what that person would have wanted, what their wishes and feelings are, what may well be best in welfare terms, has to be taken into account when any decision is made about them. Parents often get concerned about breaching the law when it comes to making decisions on behalf of their adult children. What the Mental Capacity Act says is, and the guidance around it, is that if you genuinely think that the person can't make decisions for themselves, and you've genuinely taken what you think is a best interest decision, then it's unlikely that you will be breaking the law in any respect. But it is very important that parents and carers don't just assume that they have the right to make decisions on behalf of young people over the age of 16, but that they go through a proper best interest process. And there's some very good guidance available through the Mental Capacity Act website that will tell parents what they need to do to be making decisions that are compliant with the Act. And there's a whole chapter of the Mental Capacity Act Code of Practice that deals with decision making for young people aged 16 and 17 under the Act. So there are resources out there that forums and families can use. And this is obviously an issue for forums as well, because when they're engaging with young people over the age of 16, they should be engaging with those young people on the basis of a presumption of capacity, and helping them to make their own decisions and communicate their own wishes, not just representing what their parents tell them. I know that parent-carer forums play a key role in advocating for better services and support for everyone in their local area. And I think as part of that role, it's really important that parent-carer forum leads understand what the legal requirements are, so that they can have discussions with senior managers and commissioners across the local area, informed by the knowledge of what it is exactly that the law requires to be done. Particularly in this difficult financial climate, the legal obligations are going to be even more important, because in very many areas the money isn't there to do very much more than what the law requires. So an understanding of the law at this time, I think, is going to be particularly critical for parent-carer forums.